Hello everyone. This is a second concept as relating to contract to subject. So that is bailment. Bailment is a derived from a French word that is bailer, which means to deliver. So what is the meaning of bailment? So basically bailment includes the two persons. It means to transfer of possession of some goods from bailer to bailee. To include the bailer and bailee two persons in bailment. The specific definition defined in under section 148 of the Indian Contract Act. What is bailment? A bailment is a delivery of goods by one person to another for some purpose. Upon such a contract, that contract will be that purpose will be accomplished or completed or be returned or otherwise disposed of according to the directions. Whatever the directions will be imposed of the two persons, bailer and bailee, in that particular delivery of the goods. So this is called as bailment. And the person delivering the goods to one person to another person, one person delivering the goods is called as, that person is bailer, and the person to whom they are delivered is called as bailee. Now let us see. For example, I deliver some goods. A person A delivers some goods to a jeweler B to make bangles for his sister. In this case, A is a bailer and B is bailee. And by delivering gold to from A to B. So whatever this two relationship A and B is called as bailment. And let us see the case law as relating to bailment. Revis versus Capper. In this case, court clearly held that a servant in a custody of certain particular goods, by the nature of his job, is not a bailee. And another case law, Atul Mehra versus Bank of Maharashtra. In this case, court held that mere hiring of a bank locker and storing things in it means in bank, it would not constitute a bailment. So it clearly held that it is not considered as a bailment. So essential elements as relating to bailment. First one is delivery of possession of goods by bailer. So clearly held that in the definition of bailment, it includes the delivery of goods from one person to another person. Okay. So that is the possession of some goods should be voluntarily transferred, and the delivery of a possession may be actual or contractual. So actual delivery means some goods are physically given into the possession of the buyer. That is, the delivery is an actual delivery. Okay? And contractual delivery means when some goods are effected without there being an transfer of possession. The transfer of possession is without it will be affected the some goods are not in the possession. Okay, it's a contractual delivery. The case law as relating to delivery or possession of goods by bailer, that is Kalyanmal versus Vasant Lakshmi. So in this case, Kalyanmal versus Vasalakshmi, in this case, court clearly held that the goldsmith not held liable in any bailment, because in this case the illustration is likewise a lady employed in a one person goldsmith shop for melting old jewels to make some new jewels, and every evening she used to receive half made jewels from the goldsmith and put them into a box which was left in the room in the goldsmith's house. So one day morning she found that jewelry has been stolen. So clearly court held that the goldsmith was not held liable for this bailment. So the second essential is agreement. Every contract including the agreement. So the agreement between two persons, of course Beller and Bailey, and it may be express or implied. And third one, purpose. Every act done behind its particular purpose. So in bailment, the goods are delivered for some purpose only. Or last one, return or dispose of goods according to the direction. So the delivery of goods are for a specific purpose. After the purpose will be accomplished or completed, the goods may be returned to bailer in the same or altered direction or some altered condition, or maybe disposed as a directed by the bailer only. So that one is return. So you explain, you understand this one with one illustration, that is a tailor who receives a cloth for stitching. He is a bailee in this case. Next, the tailor is supposed to return the finishing garment to customer, the bailer, once the garment has been stitched. So in this case, tailor is bailee. He acts as a bailee. Okay, and case law as relating to return. So the first case is Icha Danji versus Natha. In this case, court held that a deposit of money with a banker is not a bailment, as he is not bound to return same notes and coins. It's not a bailment. And second one, Seke of State versus Shio Singh Rai. So the court held that the government not bound to return same notes, nor was it bound to dispose of surrounded notes in accordance with the plaintiff's directions. Okay, it's not bailment also. So another important case laws as relating to bailment. First one. So the first case is Cox versus Bernard. In this case, court held that a general bailee was strictly liable for any damage or whatever the loss to the goods in his possession. And another case, Hyman and wife versus Nye and Sons. In this case, court held that a person who lets out carriage is not responsible for all defects discoverable or not. He is not an insurer against all defects. So his duty is to supply the carriage only as fit for some purpose, which is hired as a care and skill can be rendered it. Okay. And another case, Reed-Din. In this case, court held that there was an implied undertaking that the lunch was as fit for some purpose for which it was hired as a reasonable care and skill could be make it. So the defendant was held liable in this case. And another case, Lyle versus Gangadas. In this case, where a bailer delivered some goods to another for carriage or for some other purpose only, and if such goods are of dangerous in nature, so the fact should be disclosed to bailee only, from the bailer to bailee. Thank you.